human rights activist and former presidential candidate Omoyele Sowore has issued a grave warning about what he describes as a high-level political conspiracy between the administration of President Bola Tinubu and elements within Nigeria's judiciary. According to Sowore, this alleged alliance has already determined the fate of Nnamdi Kanu, the detained leader of the Indigenous People of Biafra, IPOB, long before the courts delivered their verdict. In a strongly worded post on Wednesday, Sowore claimed that the ongoing legal proceedings against Kanu were nothing more than a carefully choreographed formality designed to lend a veneer of legitimacy to a decision that has already been made behind closed doors. For the avoidance of doubt and to alert the public, it has become clear that a secret decision has long been reached within the Tinubu regime regarding the fate of Nnamdi Kanu. Sowore wrote, "The plan, devised through a high-level political conspiracy, is to either sentence him to death or condemn him to life imprisonment. This outcome, predetermined far in advance, is now being dressed up in the guise of judicial procedure." The activists suggested that the judge presiding over the case, Justice Omotosho of the Federal High Court, Abuja, may be preparing to interpret Kanu's refusal to open his defense as an admission of guilt, thereby justifying a foregone conclusion. Justice Omotosho is expected to conclude Kanu's trial by declaring that his refusal to open his defense amounts to an admission of guilt, a convenient interpretation designed to seal a verdict already agreed upon behind closed doors. Sowore stated, according to him, this legal maneuver is not only politically motivated, but also deeply reminiscent of Nigeria's darkest judicial episodes. He warned that the anticipated ruling, expected in November, could evoke chilling memories of the 1995 execution of Ken Saro-Wiwa and 8 other Ogoni activists who were sentenced under the regime of the late General Sani Abacha. It was in November 1995 that the military tribunal of General Sani Abacha sentenced Ken Saro-Wiwa and 8 other Ogoni activists to death, a sentence carried out with ruthless precision, Sowore recalled. Today, 3 decades later, Nigeria appears to be standing at the same moral crossroads. Only the year has changed. This is 2025, not 1995, but the machinery of repression grinds on. The trial of Nnamdi Kanu has ceased to be about justice. It is now a test of conscience for the Nigerian state and its citizens alike. Sowore's remarks cast a heavy shadow over the judiciary's handling of Kanu's case, portraying it as a symbolic struggle between justice and political expediency. He argued that the outcome will not only determine the personal fate of Nnamdi Kanu, but will also serve as a moral litmus test for Nigeria's democracy and the integrity of its institutions. SaharaReporters had earlier detailed that Justice Omotosho gave Nnamdi Kanu until Wednesday, November 5th, to either open his defense in the terrorism case brought against him or forfeit his right to do so. This directive followed several postponements and Kanu's continued insistence that he would not proceed with his defense until certain preliminary issues were addressed. At the court's previous sitting, Kanu had refused to open his defense for the 4th consecutive day, reiterating that he would not do so because there was no valid or existing charge against him under any known Nigerian law. He maintained that his trial lacked a lawful basis and demanded his immediate release. Despite the prosecution's closure of its case and the dismissal of Kanu's no-case submission, the IPOB leader remained firm choosing instead to submit a motion and a supporting affidavit, rather than the final written address requested by the court. In his response, Justice Omotosho ruled that Kanu's filings were properly submitted and would be considered at the time of judgment. Acknowledging that Kanu was representing himself without legal counsel, the judge stated that the defendant should be granted adequate time to seek legal advice and prepare properly for his defense. The judge subsequently adjourned the trial to November 5th, setting a clear deadline for Kanu to open his defense or risk being deemed to have waived his right to do so. For many observers, the unfolding events in Kanu's trial have reignited debates about political interference in Nigeria's judiciary, freedom of expression, and the handling of separatist movements within the country. Sowore's claims add a new dimension to these debates, suggesting that the judiciary may once again be used as a tool of political suppression. The timing of the anticipated ruling in November, coupled with the eerie historical parallel to Ken Saro-Wiwa's execution, has only deepened public unease. Activists and rights groups fear that a harsh verdict could inflame tensions in the southeast and further polarize national unity. Sowore's warning therefore goes beyond a political statement. It serves as a call to vigilance for Nigerians, civil society, and the international community to scrutinize the process and ensure that justice is not sacrificed on the altar of political expediency. This is not merely about Nnamdi Kanu, Sowore concluded. It is about whether Nigeria, 30 years after Abacha, has learned anything about justice, fairness, or democracy. If this conspiracy succeeds, then we have simply replaced khaki uniforms with agbadas, but the oppression remains the same.